I have to say that this is an amazing thing to actually get. But, you know, I don't do it just for us. I do it for you guys because it really is us all working together. And no matter where you are in your journey, it takes all of us to share our story. And it's always very hard because whenever you make a statement and you put yourself out there, you're judged sometimes, and that's hard for people to look at. But when you make something so negative a positive, it just turns all that negative into something more positive where we can have a focus. And so my motto has been that we're going to have, you have to have purpose, and your purpose is your child. And you guys just meeting everybody here, you know, we meet each other on Facebook, but to actually be able to see you in person, it's like a connection and an instant bond that is unbreakable because we get it. We don't have to explain anything to anybody because we're all working for that same purpose, and we're all at different stages, but we've all been at that first stage, and it's like a denial, and then you get to that next stage, and then, you know, you're accepting a little bit. But whatever you can do to raise awareness is so important, and whatever we can do to just bind together, because we really are in this together, and we are the best advocates for our family, and nobody else will ever be that advocate that we are, because we love them unconditionally. And I truly love every one of you. You know, I wrote something down. I'm going off the fly. You know, this morning or last night, Megan started seizing again, and you know, sometimes I just sit there and I'm like, okay, God, you're going to get me through whatever is given. I can't look at that he's going to get me through. You know, he won't put any more that's out there, or he's not going to put anything else heavy on me. But if I look at it that way, I'm like, okay, what? But if I say, you know, God, you're going to get me through whatever is given. This journey is very difficult, and you really got to pull deep sometimes. And those nights when you ask yourself those questions, what I did wrong, you know, what did I do? Why is she like this? We all ask those questions, but, you know, sometimes we don't have to have that answer. And I've learned in this journey that you don't always get an answer, but you got to be okay with things how they are currently. And that's a very hard thing for all of us. I mean, at least for me, because I like things in order. I like things on schedule. I like things having its place. And then when my life gets turned upside down, I sometimes don't know how to function. And I have to fake it to make it. But you guys give me purpose, and thank you for all that you do. Julie, you have been an amazing, when I got into this and they told us we had a diagnosis after 8.5 years, we were diagnosed improperly. And after 8.5 years to get a diagnosis, it really doesn't make the journey easier, but it gives me purpose and hope that one day, with the help of all those that are working diligently trying to find a cure, that's the purpose that we're all aiming for. And if we are quiet, we can't get the word out. And we all have to stand strong, because this journey is very difficult, emotionally, physically. And love every one of you from the bottom of my heart. Thank you so much for this. I will cherish this forever.
Thank you, April. It just occurred to me when our parents are up at midnight asking what Joseph's doing, he's probably in the lab with a time change, so it works out well. So, and on the topic of advocating for patients, I want to introduce our first speaker. Mandy Leigh, I forgot to pronounce it, is an attorney and partner of the Leigh Law Group. She specializes in special education and advocating for kids with disabilities, and has served in many hearings and trials on their behalf. And so we're very interested to hear Mandy's presentation this morning.
Good morning, everyone. So when Julie asked me to speak today, and I just saw her so sweetly up here introducing everyone, when we first met, she was quite a fireball because she had been going through a lot with her school district, and it was frustrating. And it was to the point where unraveling how the process works in order to support all of the needs of her daughter through that process within the confines of the legal realm, and how that might play out in terms of supporting her growth academically, behaviorally, socially, emotionally, intellectually. And we're at a place now where I think things are moving along a lot better. But I remember one specific question that she emailed me after we got out of a sinking hole that I feel like she felt like she was in with the school district, and that was, do I really have to keep following up with these people? And my answer was yes, every single day. That's how we advocate for children within the school system who have pretty significant medical issues that manifest in a variety of ways that impact them in their schooling. So I'm Mandy Leigh. I am the senior attorney at the Leigh Law Group. Okay. Really? 4 of us.
Sorry.
So, and I have been, I don't need a microphone. I've been practicing special education law for roughly over a decade. I have litigated special education cases on behalf of children with a variety of disabilities all the way through the Ninth Circuit Court of Appeal, as well as in the state courts of appeal. And of course, I go to IEP meetings and I work with families on a routine basis on maintaining IEPs and helping them understand what their rights are under the law. And we have a lot of material, and I tried to squeeze it in to a lot of, into a very condensed package today. So I was a teacher, so I kind of get how the process works within the schools. I also have a master's in education law, and like I said, I've been working in special education law. I do employment law for individuals with disability, and a host of other things. So what I'd like for you guys to feel like today is maybe I can give you some tips so you can go with a t-shirt that says, hey, thanks Mandy, I survived my first IEP meeting. That would be my hope for today. Of course, I just want to talk to you before we get right into it about when would you need an attorney, and when would you want to bring someone to help you at an IEP meeting. My response is always, and not because you sign a retainer with me, but I feel like the complexity of the special education laws, and we're going to talk about that today, are so difficult and so dense that school districts typically, in my experience, do not unravel for you all of the services that are available to you. And Okay, I'm sorry for the webcast. They do not unravel for you all of the services that are available to you. And it takes someone who has been through the process to kind of help you understand what is available, and more importantly, how do we measure progress? How do we measure whether the services that you've been fighting for, because so many parents fight, they're fighting for services, but services aren't enough. It's critical that we measure the value, much like the individual who's up here earlier, who is in the lab. That's what I do in a way. I'm looking at your IEP goals to determine if the services that are in place are helping your child make progress. And that is data collection. That is a data point that starts at ground zero with present levels of performance, and then in 1 year's time, we're going to look at those data points to see whether the related services have made any appropriate, more than de minimis change in your child's educational manifestations, in your child's educational benefit. And a lot of people don't put a lot of value in the IEP goals, and Julie will tell you, I do not let a parent sign an IEP unless those goals are not vague, that they are measurable, and they are designed to assist in measuring progress. Because what does it matter if you get 5 times a week of speech if your child isn't benefiting from that speech? So that's where the goals come in. But first I wanted to talk about the laws that apply to children with this particular genetic disorder. We have Section 504 of the Rehabilitation Act, and we also have the Individuals with Disability in Education Act. Now, the majority of children who are diagnosed with this genetic condition would likely qualify for an IEP, which is the Individualized Educational Plan that you get under the IDEA. Under Section 504, you get a 504 plan. And one of the critical differences is that under, first of all, there's the definitions between eligibility for both of them. But in terms of the practicality of what the differences are, under the IDEA, you get an IEP. And in the IEP, you get goals and objectives that must be met within a year's time. Okay? And there are a host of other things, but that's the crux of it. Under Section 504, you get a 504 plan. There are no goals. And typically under a Section 504, it is leveling the playing field. It is putting the ramp in so that the child can get into the classroom. Okay? Under IEP, it's intensive, individualized academic instruction, specialized academic instruction designed to meet the unique needs of the child so that they make progress within a year's time. So it's a very different set of laws. One thing I will tell you is that under the IDEA, 504 is incorporated into the body of those provisions. So if a child is on an IEP, they will naturally also qualify for 504. The reverse is not true. If you are in a 504 plan, you might not necessarily qualify under the IDEA. So a good example would be a child with diabetes. They might have a 504 plan because their performance in school, they're doing fine. They're making C's or better. We're not seeing behavior problems. They might need to miss class occasionally to go and take their medication. But they don't need specialized academic instruction, a special way of teaching, whether that's occupational therapy or speech and language therapy or remediation for their academics or behavioral services. So that's kind of the quintessential difference. I don't need to read from the slide, but I did point out to you that some of the critical definitions that are different is under 504, it's a physical or mental impairment which inhibits a major life activity, including, and then all of these lists of impairments. Now, one thing a lot of people don't know is that both 504 and the IDEA have what we call a FAPE provision, F-A-P-E, and that stands for a free and appropriate public education. So where do your rights come from? Your rights come from a whole lot of places, which is why when I started my presentation, I said, why would you want to bring an attorney or a non-attorney parent advocate? This is why. The laws that apply to disabled children in schools are extremely dense. There is a lot of law. And typically, in my experience, the educators who are on the ground working with your children only have very surface knowledge of these rights, whereas a special ed attorney or parent advocate really understands these laws and how they play out in the IEP process. So where do your rights come from? They don't just come from the IDEA. I get a lot of people who search the internet and they start reading, oh, I read this publication or I went to this website and that's what this says my rights are. But that may just cover one area of the law. It barely breaks the surface. When we're talking about your rights in school, there's federal statute, there's state statute, there's federal regulations, there's administrative regulations. Of course, there's judges who interpret the regulations and the code. So there's an incredible body of legal analysis of the application of these laws. There's opinions from the Office of Civil Rights. OSEP is a department agency from the Department of the United States Department of Education. They implement decisions and orders. Then I haven't even gotten to the state level, and I'm sure I'm forgetting some. There's the California Education Code, the administrative regulations interpreting the code. Then there's the case law that comes from the administrative bodies. If you get into a dispute with your school district about whether their offer is safe, there are judicial, and then there's the California Department of Education, and they implement orders and decisions. So this is all the stuff that I have to know. And when you're going in as a very emotional parent and your child has just had a cluster of seizures and you've been dealing with that and medication and they're not doing well for the first day or two after they're released from the hospital or even longer, thinking about this stuff is an incredible amount of information to be burdened with while you're trying to keep your child both physically and mentally healthy, as well as still progress them along academically so they don't fall so far behind their peers that there's no catching up. And that is capable if you know these areas of the laws and what your rights are. So the state definition of a free and appropriate public education, and this is the crux of the IDEA, this is where it all is, this is the meat and potatoes, is that the California legislature finds and declares all individuals with exceptional needs have a right to participate in free, appropriate public education and special education instruction and services for these persons are needed in order to ensure the right to an appropriate educational opportunity is available to meet their unique needs. Critical words I want you to remember there. Unique needs. This particular genetic disorder manifests in many different ways in all of your children in the room. I'm sure some of you have very different, while you have some similarities, there's also some very unique differences among all of the children that I've been representing, and I'm sure even in this room with the parents. And that is a really important thing to know because each IEP must be designed to meet your child's unique needs, to make sure that they receive a free and appropriate public education. So what does special education mean? A lot of people don't even know what it means. They just go in saying, I want behavioral services. I want a teacher one-to-one. This is the definition. Special education means specially designed instruction at no cost to the parent to meet the unique needs of individuals with exceptional needs whose educational needs cannot be met with modification of the regular instruction program. So in other words, if we just shorten their assignments or we give them extra time for tests, those are things we might see on a 504 plan. That's not going to do it here. These are kids who need far more individualized intensive services to meet their needs. Cannot be met with modification of the regular instruction program and related services at no cost to the parent that may be needed to assist these individuals to benefit from specially designed instruction. So it's free. That's the deal. Now, I do have bad news. The judges in this area of the law have decided that they've set a standard. It's called the Cadillac standard. Some people also call it the Chevrolet standard. So basically, FAPE is a basic floor of opportunity. It is a basic floor of opportunity. It is not the best. It is appropriate. And that basically means that it is the Chevrolet, it is not the Cadillac. And that is based on U.S. Supreme Court case law and judicial interpretation of the federal statutes. So basically, when you go into IEP meetings, one thing that I advise clients is never use the word best. Sorry, I'll step back too. The minute that you use the word best, the school district is already like, aha, they want the best, and they're already going to lower the bar for you. So it's it's the basic floor of opportunity. And the way that I like to look at that is that we're not talking about no opportunities to benefit. We're talking about the basic floor that allows your child to meet their goals in a year's time. So that's why those goals are so important, because while a school district will say, no, parent, it's not the best, it's appropriate, it's a basic floor, that might be the case, but my analysis stems from the data point collections that the school district is taking that are tied into those IEP goals so that I can measure when I get a case whether that child is making progress. And the standard for measuring progress is that it has to, and this is also from case law, it has to be more than de minimis or trivial progress. So if Johnny can just sit up now after a year and pay attention in class, is that more than de minimis progress? Or is that incredible progress? The answer, it depends on the child. if Johnny has been so inattentive for a year's time, and one of the IEP goals was to get Johnny to sit and pay attention in class and comprehend the class lecture, that might be progress for Johnny. But it might not be progress if that has no relationship or nexus to the IEP goals that the team has developed. If a teacher comes into an IEP meeting and says, well, we really got Johnny to start paying attention, but none of his goals are met. He still hasn't learned how to read. That is not more than de minimis progress. That is no progress. And that is one of the central features that I'm looking for, as I said, when I'm looking at data points and data collection for whether an IEP is designed to meet the child's unique needs. So a lot of families come to me and they say, well, my child has a diagnosis, and why aren't they eligible automatically? And they're not. Because under the IDEA, there's a process for determining eligibility. So not every child who comes with a medical diagnosis is automatically deemed eligible under the IDEA. They might be deemed eligible under Section 504 of the Rehabilitation Act because their medical diagnosis is a mental or physical impairment that affects a major life activity like reading, writing, sitting, jumping, all of those things, the list that I gave you on the previous slide. But under the IDEA, it starts with assessment. Because eligibility under the IDEA is based on legal definitions of eligibility that are not the same as medical diagnoses or even diagnoses that a psychiatrist or a psychologist might give you under the DSM-4 manuals that they use to diagnose. There are legal criteria, and it starts with what we call child find. So child find is a term of art under the IDEA that are used by special educators and attorneys, and it defines the process for referral for assessment. And the school psychologist does not have to be a PhD. They can be a master's level evaluator. And the reason that is in place is because under the IDEA and under California State Education Code, school psychologists are not allowed to diagnose. They can only determine eligibility under the legal definitions of the IDEA. So that's really important for you to know, because a lot of you have been so involved in the medical piece that you're surprised and shocked to know that the person at the school district who's evaluating your child does not come with a PhD and is not formally diagnosing. They are checking off boxes for legal categories of eligibility, and we'll get into that, and there are 13 of those under the federal law. This slide just defines basically how child find and how referrals can be made. Now, one thing that I find pretty interesting about this body of law is there are so many acronyms that when I argue my cases in federal court, the judges are looking at me as though I'm speaking another language, and I have to slow it down and kind of break it out because it's so specialized. And we're talking about some of the smartest, people in the legal field, but there are lots of lawyers that I've represented as well and their families, and they don't understand these acronyms. So I wanted to go over them, and if you're taking notes, either on the web or now, I think it's critical that I do that. Let me see if I can find that slide again. I may have just, oh, there we go. Okay. So LRE stands for the least restrictive environment. I'm just going to go over them. CDE stands for the California Department of Education. The IDEA is the Individuals with Disability and Education Act. Of course, there's No Child Left Behind. FAPE is a free and appropriate public education, which I've defined for you. IEP is the Individualized Educational Plan. HQT stands for Highly Qualified Teacher. 504 comes from Section 504 of the Rehabilitation Act. And DIS stands for Designated Instructional Services, which are the services that are speech and language, behavioral services, occupational therapy, physical therapy. They are the related services that support your child in meeting his or her goals within that year's time, when you have your annual IEP. Now, least restrictive environment is a critical one, because the least restrictive environment standard means there is a spectrum. So a spectrum of placements. That means that school, your general education setting, would be the least restrictive environment. It's where all kids go to school. We expect all kids to be in a general education classroom setting. However, there are some children, whether it's because of their mental health needs, their behavioral needs, or their medical needs, that their needs simply cannot be met in a general education classroom. So then we start looking at the spectrum. So what would be the next or lesser of the restrictive environments is the classroom, and then more restrictive would be a special day class. And then more restrictive might be a non-public school or a private school that is designed with particular services embedded to meet your child's need, but all of the student population are disabled children. Then after that might be the home setting, residential treatment facilities, medical facilities, hospital facilities. It goes on down the line. So the less exposure to typical neurotypical developing peers is where we are in that spectrum. That sort of governs and defines the least restrictive environment. And there are a lot of cases where parents have fought with school districts, what is the least restrictive environment for their school, for their child, and then we also get into things like inclusion versus mainstreaming. Can a child be fully included in a classroom with all of their related services embedded into the classroom, like push and OT and push and speech, or do we need to pull them out and put them in a more segregated environment so they can learn some of those skills? And these are all the tools that I'm looking at when I'm looking at the developmental levels of the child, their present levels of academic performance, their medical needs, their behavioral needs, their ability to socialize. Is it appropriate to put that child in the classroom so they can mimic their typical peers and learn that back and forth, socialization piece? These are all the dynamics that I'm bringing into an IEP meeting when I'm looking at psychoeducational evaluations, medical evaluations and diagnoses. And, sometimes I'll have parents bring in a letter from, I know there are some researchers and doctors, and hopefully this will resonate with you, a one-pager with 3 sentences from a medical practitioner or researcher, or whoever they're working with, saying, we think that this child ought to be fully included with all services pushed in. That doesn't help me, because the educators who have been working with the child for 8 hours a day have had an opportunity to observe that child in the academic setting. So unless that practitioner has actually gone into the academic setting to observe the child and has talked to the teachers and has done their due diligence in observing what a FAPE is for that child, a one-page letter isn't going to do it in the special education realm. And I know a lot of parents do that. Their first line of action is, well, I'm going to go get a letter from my doctor saying that my child needs X. But legally, that doesn't have a whole lot of weight in terms of development of the academic pieces or the IEP, because that person has not gone into the classroom to do some research to determine what is not working, and they don't always have the fundamental understanding of what services are available to assist that child in meeting the goal of the IDEA, which is to meet those goals, those academic, behavioral, social, emotional, speech and language, or mental health goals. Now, that would be different, that's a different scenario when a researcher or a medical practitioner or doctor, psychologist, psychiatrist writes a letter about a health care plan. In the case of a health care plan, that's pretty much a given that that person is the expert, and of course there's a lot of case law that talks about, and we've seen decisions, that the health and safety of the child always comes first. So there's a little less leeway in terms of a school district's ability to make its own decisions about medical necessity and treatment for that when we're talking about health care plans that have been designed by your outside physician. So these are the categories of eligibility under the IDEA. These are the checklist impairments that school psychologists are assessing for, and they're defined in the California Education Code, and they're also defined in the federal statute. So I've given you both of the places you can find the definition at the bottom. 34 Code of Federal Regulations 300.8A1 is where you can find the definitions for these under federal law. And then in the state of California, they have their own regulations, and that's Title V, Section 3030. And this is what you ought to know before you go into your IEP. Because if you don't know these definitions, you don't know what to ask for. This helps us carve out what your child's unique needs are. Now, there is recent case authority that says, you know what? It doesn't really matter whether your child gets a specific label or not. And once your child is in, that's the golden ticket. As long as the IEP addresses all of your child's unique needs, then Litigation over eligibility is now gone down the drain because the Ninth Circuit has a decision out saying, say Johnny has ADHD, but the team determined that the ADHD is not impacting his education, it's the speech and language impairment. If he has inattention and any of that is affecting his eligibility, even if he doesn't get deemed eligible under the IDA because of his ADHD, as long as they're addressing his inattention in the IEP goals and with specialized academic instruction, then you're in. So the judges have held that it won't matter that you don't get the category of eligibility that you want. So in these cases, we're looking at potentially intellectual disability as one of the categories of eligibility, speech and language impairment, sometimes visual impairment. Other health impairment is a critical one, specific learning disability. Autism also might be a category of eligibility, which is now called autistic-like. It's not actually called autism. It's not referred to as autism anymore. So these are defined, and I'm not going to go over the definitions, but I did want to touch upon other health impairment, because other health impairment is not a diagnosis. That's a good example. Under the DSM-IV medical criteria, there is no diagnosis called other health impairment. It is a legal label. And other health impairment is limited vitality or alertness, which is the result of an acute or chronic health condition which affects the child's ability to access their education or to benefit from their education. So it could be ADHD, it could be epilepsy, it could be diabetes. It is a medical condition which causes inattentive manifestations. So much so that the child cannot make progress like their neurotypical peers could. So that's just a good example of how the definitions under the IDEA have nothing to do with medical diagnoses, which causes a lot of confusion for families. And again, I've already talked about the eligibility criteria under Section 504 and how children who are typically deemed eligible for an IEP would also be covered under Section 504, but the reverse is not true. So these are some of the major life activities that qualify an individual under Section 504. Performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. And I gave you the provision in case some of you want to go down the rabbit hole of Googling the Title 20 USC 12102 2A section. So how can I help you best prepare for your IEP? And I've come up with a couple of tips, and this is where I think it's really critical for you to pay attention. So first of all, you need to know that you are part of the team, okay? And being part of the team means that you've got a lot of information to share. The school district and the personnel, the teachers, all of those folks that work with your children don't necessarily see what you're seeing. I'll give you an example. If your child has a cluster of seizures and the next day they're out of it, but they might be able to do some reading, your school doesn't know that. They're not experts in this area. So you have got to make sure you are constantly communicating in writing to these folks what is going on with your child academically. If you do not, they do not understand your point of view when you show up to the IEP meeting. They are lost. They think the child is just walking in all fine 2 days after they've been released from the hospital. Okay, it's critical that you keep them up to date in writing about what is going on and what the affect of those seizures or other medical needs that are going on within the confines of their day, because then they legally must address those unique needs. Maybe it's home hospital instruction and sending a teacher to your home. Maybe related services like speech, language, and behavior services need to come to the home because the child can't make it into school for a period of time. It is critical that you are in constant communication so that you can advise them about your child's unique needs. What's the best way for you to contribute in addition? You need to know who you can bring to the IEP meeting that can tell the staff about your child's needs. Maybe you want to bring the treating physician the first day. I've done that plenty of times. I ask the pediatrician to come to the IEP meeting, and I coordinate the dates with the IEP team so that pediatrician can spell out what the team can expect with this particular diagnosis, because this is complex stuff. It's complex for you. It's certainly complex for these teachers who are dealing with 20, 30 kids in a classroom, and they've got to implement federal law. So it's not a bad idea to bring someone who is a specialist who knows your child, who can also listen to the team when they're making recommendations, because maybe your pediatrician might say, like, a full day, she can't handle it. She can only handle 3/4 of a day because her medical needs are such that she fatigues by 1 o'clock. Then the team's got to figure out how they can provide those services maybe in the home. So it's really critical to consider what experts might help the team develop a really good IEP plan, especially also in the case of this particular genetic disorder, because of the fact that there are so many different ways that it manifests, like the degree of intellectual disability, the degree of social communication deficits, the degree at which the child may be hospitalized. All of those moving parts have to be addressed through the IEP. And if you bring a specialist, they can kind of lay that out for the IEP team. And you don't have to do that for every single IEP. I think it's a good idea to do it, as often as you can get your pediatrician or specialist psychologist, neuropsych to attend. So the Ninth Circuit Court of Appeal, which is the appellate court right below the Supreme Court, they make a lot of heavy-hitting decisions about this stuff. They have talked about the procedural safeguards. Now, the procedural safeguards are a packet that you get at every IEP. How many of you have been to an IEP meeting, if I can see a show of hands? Okay, so at every IEP meeting, when the special ed director says, do you want your procedural safeguards? And they hand that to you. There's legal significance to that, because if you're not given your procedural safeguards, that can be a violation of FAPE. Because one of the key provisions of the IDEA is that you sign the IEP with informed consent, that you understand everything, and it's spelled out in layman's terms, so that when you sign that contract with that school district, you're signing that you understand everything they're offering, the goals, the services, the modifications, how long, how often, all of that stuff. So those procedural safeguards, if you haven't actually read them, you really, really should. And a lot of parents don't. So you are a critical player in the development process to the IEP, and the failure to not include you is a denial of FAPE, okay? And the duty, we've seen a lot of legal decisions now and opinions coming out of courts that support that if the parents' input was not considered, or the district didn't allow the parent to make informed decisions, then there are violations and denials of FAPE, and parents have prevailed in the special education administrative hearings and in court. So one of the things, what does informed consent mean? How do I make myself informed? So I talked about bringing a physician, okay, or bringing an expert, bringing someone who medically treats your child. But other people are, maybe you're getting private speech services, private OT services. Those are people you can bring, okay? Those are really critical people. Another thing that I like to do is I like to have families take tours of the placement before it's being offered. Have you ever asked your school district, before you make me that offer, I need to make an informed decision. I'd like to observe the classroom. You have the right to observe. Is the teacher, are they overwhelmed? Do they seem really trained? Are they new? Do they have experience in fully including a child with special and medical needs into a general education classroom? I also like to find out, what's the collaborative model at your school site? How do the related service providers, speech, OT, behavior, psych, counseling, et cetera, collaborate with the teacher to make sure that all of those services are implemented throughout the day? So there's a lot of different things to be informed. I also like to make sure for every child that ever go, and I know Julie can attest to this, I know that child's records like the back of my hand. I know how many times she's been absent from school. I know what her medical condition is about. I have researched it myself. I've looked at all the data points on previous IEPs and where the deficits were in those goals. I've rewritten the goals. I make sure the parents have observed the classroom and the school setting. It is a lot of work to be informed. It's not just showing up in an IEP and saying, I have a disabled child, please help me. It doesn't work that way. But it sounds like a lot of work, but once you get into this routine and this habit of making yourself informed, trust me, it will make your IEP process so much better, because you will be prepared to ask the right questions. So I saw in your classroom, Ms. Smith, that at the front of the board, that you mostly teach at the front of the board. But my child has attention deficits and a comorbid condition of ADHD with the genetic disorder. So what will you do? Because if you teach at the front of the classroom, my child isn't going to comprehend any of that because they're going to be too inattentive to learn. So I will have those kinds of critical questions designed to develop that appropriate IEP because I've made myself informed. So that's some key information that I want you to know that you may not have known that you are allowed to do. So how does a school violate the IDEA? Well, they do it when they don't allow you to have meaningful participation. You have identified significant needs to the child and they have just completely ignored your child's needs, and as a result your child is not meeting those central goals of the IEP. After the fact, parent involvement is not enough. A school district may not enter an IEP with a take it or leave it position. How many of you have felt that way at your IEPs? That you've walked out of there and you're like, they didn't hear me. I made specific requests and they didn't hear me. So who needs to come to your IEP? The parents of a child with a disability, not less than one teacher, not less than one special education teacher, a representative of the LEA, which stands for Local Educational Agency. It's a definition under the IDEA, and it means your school district. And these are the criteria for an administrator who needs to come. There is nothing that irks me more than when a school district sends an administrator who says, I have to check with the special ed director. You have to have a person at the IEP who can sign off on the decisions of the team when everybody's agreed to say, something like medical management or counseling services, and the person says they have to go check with somebody else. That means they violated the IDEA because they've got to send these people. These are legal requirements under the IDEA. Critically, they have to have someone who can interpret the results of any evaluation at the meeting, and I will let you review the rest. It's all in the slides, and I tried to be as detailed because I wanted to make this a reference tool for parents and practitioners after this conference. You will get the team asking for excusal of a team member. It's your choice. If you need to reschedule it because you think that the psychologist being present is critical, then do that. Don't feel bullied or forced into excusing a team member. Also, if in order for you to excuse an individual, it has to be in writing and you have to approve it. They can't not just send the person because they're not available. So building your support, here's some people you can consider bringing to your IEP, an advocate, a friend, a regional center representative. A lot of you in here probably qualify for regional center services under intellectual ability or autism or some of the other mental and physical impairments. And of course, you need to prepare. Also in the state of California, you're allowed to audio tape your meetings as long as you give written notice within 24 hours of the meeting. Always audio tape your meetings. Always audio tape your meetings. If you have a conversation with an educator outside of the meeting that is about your child's needs, always document that in writing. I talked to you today, Ms. Smith, about Johnny having a lot of inattentiveness in class. And I understand we've come up with a system of general education interventions, like giving him his materials before class so he will have a head start of the other kids to start his assignment. Okay, that's just one strategy I've just come up with. Document. This is what we talked about. Because the more you document, if those interventions that are kind of, you're documenting as long as they don't alter the IEP, they're sort of informal changes, but they're also documenting the child's needs. And if that's going on over a period of time, you want to be able to show up to that meeting and say, I've got 50 emails of his inattention. So please don't sit here and tell me that this is hyperactive type ADHD. This is inattentive type ADHD, and I have it documented. And this is a critical point that you're constantly documenting those issues. And I bring up ADHD because I know some children have comorbid issues with this disorder with ADHD, among others. So I've just kind of outlined for you who are the required participants and how to prepare those experts for your IEP meeting. I talked about bringing experts. You might want your experts to prepare a written document, an independent assessment of your child, and present that to the IEP team if they can't appear. Notice regarding attendance, you should provide written notice of the additional attendees. I've given you a checklist of how to prepare. I talked about audio taping, having your experts attend, and I also like to give, prior to every IEP meeting, my top 3 to 5 things that I feel like should be talked about at the meeting. What are some needs? It could be anything from extended school year to behavior services to requesting assessment. Do it before, because I like to not sandbag the team. That way they can have the critical members appear and we can really talk about those items. Did you also know that you have the right to request your child's cumulative educational file? That is critical. If you haven't done that, after today, please send an email to your school districts and get a copy of your child's comprehensive educational file. They have to provide it to you within 5 days. Why? Because if you don't know what they're writing about your child, how are you the better expert than them? You have to stay on top of your child's educational record. So what I do is I create a table of contents, and I take that educational file, and I keep a list of every record, and I create an Excel sheet, and on the 3rd row, I make comments about each of those documents. So that when I go into an IEP meeting for a child who's now in high school, and I've been representing them, say, since preschool, I have a long history of my notes so that I have some data points about whether things are progressing along. And I can't tell you how helpful that is. I have seen some of the most severe children with the most severe needs, and I have helped them get to college. And so these are tips that will really, really help you along the way as you progress through the IEP process. I promise you that these things will make you the better advocate at your IEP meetings. I talked about tape recording and the 24 hours notice and inspecting a copy of your child's records. Documents to give, my fancy pants here slide. Provide any reports or assessments to the IEP team in advance. A lot of parents ask me, should I hide the ball? Answer, no. Do you have your ed records, etc., etc. Can I get a time check? Do I still have?
2 minutes.
2 minutes, okay. So I talked about the agenda. I would like you to prepare a list of your questions prior, how to handle a draft IEP. They're okay as long as you can change responses by providing your input. You want to get all of your assessments prior to the IEP. Goals and objectives, make sure you review them. I've talked about the importance, and make sure you understand them. I've also talked about ways of measuring those goals and objectives. Track your goals over time, okay? And make sure you understand. This is a lot of stuff. Informed consent, critical. Doing your observations. Home and hospital is going to be really important for you because a lot of children have to, after medical treatment, need to be at home. Make sure at your IEP you talk about the backup plan B for how your child would be instructed if you're going to be absent for a period of time, and I also define that. Extended school year is the right to have summer school programming because your child would regress without those services. That is a legal standard. So if you can show that your child will regress without services over the summer, then your child is entitled to summer school services. I'm not going to go over these cases. I've outlined them. They are cases that deal with children who have had epilepsy and how courts have dealt with epilepsy so that you have an understanding of what some of the battles are that parents have had to go through, everything from transportation to least restrictive environment to academic services. Lastly, these are some resources you can check out. The CDE website has a plethora of information about special education. Special Education Rights and Responsibility by Disability Rights of California. They have a free publication online with a Q&A. Answers everything you need to know about special education. At least to get up to speed. The Office of Civil Rights has good literature. The Department of Education and the Office of Administrative Hearings, which is the special education, which is a division that presides over hearings of disputes between families and their school districts when a child has been denied a free and appropriate public education. Lastly, I'd like to invite you to our Facebook because I post a lot of information about advocacy and special education rights and how to obtain a FAPE. And I think I met my 2-minute warning, so am I allowed to take some questions?
Absolutely.
Okay.
I'm sure there's going to be flying hands here. Thank you. That was fantastic.
Thank you.
Hi.
I can ask you about this afterwards if it is too detailed, but I thought I should maybe do it in front of everyone in case other people can relate. I have a 3-year-old, and she's about to go through the eligibility process. She's almost 3. She'll be 3 next month, and they're going to be doing some testing. And we had the child study meeting where they just talked to me, and they basically kept saying over and over again, if she doesn't show significant delay, she won't be found eligible. You need to prepare yourself for that, because at this point she is doing pretty well in a lot of areas, but there are areas where I'm already seeing she's falling behind. So my question is, they're saying she needs to, have a delay, but under other health impairment, it seems like she would already qualify based on having seizures and being in the hospital. And so I just wonder if I should push back on that or how.
Yep. So
And maybe one quick thing, we have representation here from all over the country, so I'm not sure how many of the laws are California specific as well.
No, so I'm gonna address it from a more global, and this would be a global answer anyway, just what you're saying, because of the definitions under IDEA, which take precedence always over state law anyway. And of course, each state has their own criteria that further defines the federal definitions. So without knowing the specifics of your case, you're right. I think you need to ask them about the other categories of eligibility. And does she meet other health impairment, limited vitality and alertness? But one of the critical pieces, and this is where I want you to focus on, and all the parents in the room or whoever's watching, is that embedded in those 13 categories of eligibility, a child might have limited vitality and alertness, the result of an acute or chronic medical condition, but you have to show that the child requires specialized academic instruction. So I gave an example earlier that a child could have diabetes, but they're a straight A student. And maybe their diabetes medication wears off and they become sluggish, and so that causes them to be inattentive, and therefore they start to fail. But if general education accommodations like letting them get extended time to complete those assignments after their medication kicks in will do it, they're not eligible. So the question for you that you need to make to the team, I would say, is 1, have you considered all of the 13 categories of eligibility, including other health impairment? 2, do we think that she requires specialized academic instruction in order to benefit from her education? Okay, speech and language, OT, a one-to-one instruction because she's too distracted. Or is it just general ed accommodation? So for a child who just has a lot of absenteeism, they may still have the intellectual functioning to keep up with the other children, but if their hospitalizations cause them to be so far academically behind that they can't get caught up, and general education interventions aren't going to assist them in getting caught up, I would argue a case for eligibility under other health impairment. So this is why you really need to know the definitions, but everyone needs to know that even if you meet the first part of the checklist criteria, if you can't prove that without special ed, your child won't be able to access their education, that's the crux of it. If you can say for an even single moment that general education interventions like extra time on tests, modified assignments, longer time to complete work, isn't going to do it, then you don't have a case. I mean, if it's not going to do it, then you will have a case. But if they can say, well, if she's absent a little bit, but she's still functioning with her typically developing peers and everything looks fine right now, then you're not going to get eligibility. I will also say, and this is another critical point, is that right now she's 3, so she's little. So they're comparing her to what the demands are academically in that 4-year-old classroom, that preschool classroom. Fair enough, because under the IDEA and state law, we're looking at what's called present levels of performance. How is she performing now compared to what her demands are of neurotypical peers? If she can meet the demands now, she's not going to be eligible. If she can perform at that bottom floor of opportunity, that basic floor. If, however, she cannot, we're looking at eligibility. Now, it's based on what we know about her now. There's another legal term of art. It's based on case law that the team's orders are to look at what we know at the time we meet. Now, when she gets into kindergarten and the demands are much more different, there's transitions, there's larger classrooms, there's now academic demands placed. They're teaching phonics and decoding, etc. And socialization's important, toileting. I mean, you name it. If at that point it looks like she's now falling further behind her peers, it's possible that they may deem her eligible at a later time, but sitting here today, her present levels of performance show her at a level where she can access her curriculum. I don't know enough about the files, but that's a lot of information, but that's the discussion I would be having.
Thank you.
Thank you for all of your information. That's super helpful. I'm just wondering, since there are a lot of us in attendance from different states, can you point us to where we could find our state-specific regulations?
Yeah, so a great place to start is your Department of Education for your state. And I practice in Idaho, I practice in Oregon, I mean, I practice nationally. When I am, the first order of business is to look at your Department of Education's website. They almost always have their regulations and their definitions on their website. So, Idaho State Department of Education, Montana, Florida, you're always going to find those regulations on their website. It's a great place to start. And then you can start looking at your disability rights organizations. They almost always have manuals or printouts online that you can take a read, some Q&A information to start getting you up to speed on state specific. And the first place I would start is the eligibility criteria. If I were looking, I would start with eligibility, because I'd want to know what eligibility my child may or may not fit in terms of those legal definitions.
Thank you.
Is that it? Thank you, everyone.
Actually, I have one question, because I think this goes both ways. So a lot of what you're speaking to is how we get kids the extra special ed services. Certainly with this group of patients, we have some kids that are in general ed, but because of the nature of their cluster seizures and need for rescue medication, at least here in California with basically no more school nurses, we often get the feedback that they need to be put in a lower functioning class where there is skilled medical nurses or LVNs that are willing and able to give rescue medicine. So can you comment on, and specifically in maybe in terms of medical needs in the law for that?
And one of the cases that I had on one of the slides actually touched upon that. And you're asking me, what is the least restrictive environment? That's the world we work in for a child who has medical needs but can academically perform at same age peers. My analysis would be, without knowing the full breadth of the record, one of the crux of the IDA is least restrictive environment. So you can't just put a child in a classroom where they're not getting all the social, academic, emotional, behavioral benefits simply because it saves you a dime on the medical piece. That's absolutely a denial of faith. That would be my opinion. How a judge sees it, I couldn't predict. Thank you, everyone.